Hi, my name is Mark Biernath. I'm an estate planning attorney here in the Atlanta area. In this section, we're going to take a closer look at Georgia's Advance Directive for Healthcare. This is a critical healthcare document that every adult over the age of 18 who has capacity should have in place. This is where you can nominate someone to make decisions for you concerning your healthcare if you're not able to. This is one of the documents that can help you avoid the need for a guardianship for yourself if you were to ever lose capacity.
Another form of power of attorney is the Advance Healthcare Directive. This is brand new, now maybe a year old. The Advance Healthcare Directive takes the place of what used to be called the Healthcare Power of Attorney and a living will. And there was a lot of confusion with the living will. That was a good document to get rid of, because most people were actually making selections on that document that were exactly opposite of what they wanted. The Advanced Healthcare Directive goes a long way towards helping with that. It's still not perfect. But with the Advanced Healthcare Directive, you designate a person to make healthcare decisions on your behalf. So this is a limited power of attorney because it's limited to healthcare decisions. It doesn't deal with your finances. And they have a duty to make the decisions that you would make, not the decisions that they would make for you. That's a difficult distinction to make. And so it gets important as to who you select as this decision maker. If the person you want to name does not hold your beliefs and would not make the decisions you would want to make, they should not be your decision maker. Because this is where people will fight about. But they have the duty to make the decision you would make, not necessarily the decision that they would make in that circumstance. Having an Advanced Healthcare Directive should avoid the need for a guardianship. So if we can do a healthcare power of attorney, we can avoid the guardianship aspect. Now there are other reasons why we might want to do a guardianship anyway, but healthcare decisions, if you have a guardianship in place, the guardian is empowered to make those healthcare decisions. If you yourself have granted someone else the authority to make those healthcare decisions, then you should not have the need to have a guardian unless your decision maker is no longer able to make decisions. And the living will is now incorporated into the Advanced Directive for Healthcare, and basically it's still limited in scope. In Georgia, you are the two circumstances which the living will portion of the Advanced Directive for Healthcare covers is if you are in a state of permanent unconsciousness, which used to be called coma or persistent vegetative state. Now we use the terms persistent state of unconsciousness, or if you are diagnosed with a terminal condition. And there's no time limit on the terminal condition. And I kind of joke when I'm going through this with people that, life is a terminal condition. Life will end somehow, some way. But generally what they're looking at in this document is hospice's definition of a terminal condition, which is generally not reasonably expected to live longer than 6 months. Doesn't mean if you don't expire within 6 months that avoids everything. You're still allowed to continue living. But, if that's kind of the definition that they're using. If you're in one or both of those circumstances, then you can make some choices. And the choices are A, keep me alive for as long as possible, do everything possible to keep me alive. B, allow my natural death to occur, don't do anything major, just keep me comfortable, give me pain medication. And then C basically says, don't do anything extraordinary, but I still want to have, and then there are 4 options. Nutrition by feeding tube, hydration by IV, respiration with a respirator, and if my heart stops, restart it with CPR. I'm not quite sure why that 4th option is in there, because it seems inconsistent to me that you'll select, allow my natural death to occur, but if my heart stops, restart it. So, and I've got some clients who are doctors, and I've asked them to explain that to me, and they scratch their heads going, I'm not sure what they're shooting at here either. Some say, well, you don't want any extraordinary measures, but if all it is CPR, go ahead and do that. So, I don't know. I'm just a lawyer, so. Also, in the Advance Directive for Healthcare, there's an opportunity to designate a guardian. So if, for some reason, even though you have one of these things, a guardian is still needed, you are allowed to nominate who you want to have as your guardian. This is important because one way some people like to get rid of other people's estate planning, think of mom in the nursing home and now the kids are fighting, is to go petition the court to be named guardian. Because once a guardianship is established, all the powers of attorney disappear. And there's the opportunity to rewrite mom's will. And so this is one way to kind of circumvent what mom already decided to do. This is how we say, okay, court, if you decide I do need a guardian, I want you to pick the people I've picked in the order I've picked them as my guardian. So it's a little bit of insurance to that situation where mom's in the nursing home and now the kids are fighting over who's going to take care of mom's stuff. Usually they're not fighting over who's going to take care of mom. They're usually fighting over who's going to take care of her stuff. So, and we have an issue with HIPAA. How many of y'all are familiar with HIPAA? Health Insurance Portability and Privacy Act. Doctors are not permitted to disclose private personal health care information with people who are not authorized recipients of such information. Well, how do you become an authorized recipient? Well, the doctor has a form where you can list some names. That's good. But what if you're in a hospital in an unfamiliar city and nobody's been there before to sign a document that says, yes, you may talk to so-and-so? One thing that I do with my clients is we do a HIPAA authorization. Basically, it's a generic authorization saying, doctor, a hospital, anybody who has a medical record on me, you are permitted to share that information with. And then we identify specifically who they can share that with. We identify whoever you name as decision makers, anybody who has any kind of fiduciary responsibility to you, maybe anybody who's going to be caring for your kids, in some cases your kids, just kind of as insurance. Technically, is it necessary? Probably not. However, I find doctors are much happier to have a piece of paper that they can stick in the file and point to and say, I'm authorized to disclose this information, rather than not having specific authority. HIPAA only provides penalties for doctors. There are no rewards for doctors for properly sharing information. And so, naturally, the doctors get conservative about sharing information.
In this section, we took a closer look at Georgia's Advance Directive for Healthcare, a critical document that every adult over the age of 18 should have in place. In the next section, we're going to look at some of the requirements and limitations for entering into either a healthcare power of attorney or a financial power of attorney. So please join us.